me going away will leave my 18-year-old take care of my dad by himself.
All right, what have you been doing while you've been on probation? Because you have not been reporting.
Yes, ma'am. Well, we did move out to Pipe Creek, Texas. And my dad's health was up and down in the middle of us relocating. So we actually ended up leaving behind, half of our belongings at the old house and not even going back for it because my dad having to have surgery and being in and out the hospital.
In 2021 CR 7243, State of Texas versus Jessica Lee Johnson. Can I have parties announced for the record for the state?
Thank you for the state, Your Honor.
Defense?
John Robertson from Ms. Johnson.
All right, and are you Jessica Johnson?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. First, state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. And second, state's motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jessica Lee Johnson, who was placed on deferred adjudication in 2021 CR 7243 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 8, 2021 for a period of 5 years? Is that you?
Ma'am.
All right, state.
This is on the first motion, Judge. Violated condition number 2, on or about the 6th day of February. I'm sorry. Violated condition number 4, in Bexar County, Texas, the defendant, Jessica Lee Johnson, did then and there fail to report to the supervision officer as directed for the months of April, May, November, December 2022, and January 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And then, Judge, this is on the second state's motion to supplement pending motion to enter. Violated condition number 4, in Bexar County, Texas, the defendant, Jessica Lee Johnson, did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, and August 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And Your Honor, we waived and abandoned the other violations alleged in the motions.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation of conditions 4 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
Court will find violations 4 and 4 true. Is there a proposed agreement?
No, Your Honor.
All right, state, what are you requesting?
Your Honor, we're asking that you grant the motion, adjudicate the defendant guilty, and sentence the defendant to 10 years to do.
All right, defense, what are you requesting?
Your Honor, I'm requesting the court consider something other than revocation, or if revocation is going to be imposed at a number less than 10 would be more appropriate. Ms. Johnson would like to address the court, kind of explain her situation. She advised me that her situation recently has actually improved as far as the stability of her personal life. She's had a lot on her plate the last year and a half or so. Has admittedly not performed well on probation, but she would like to address the court and explain it.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jessica Johnson.
All right, what would you like to say?
Just now that I'm in a better, stable environment, and my dad's health is a little better under control. And I was gonna try to ask for a final chance with probation being in the new county that we've relocated to. Me going away will leave my 18-year-old take care of my dad by himself.
All right, what have you been doing while you've been on probation? Because you have not been reporting.
Yes, ma'am. Well, we did move out to Pipe Creek, Texas. And my dad's health was up and down in the middle of us relocating. So we actually ended up leaving behind, half of our belongings at the old house and not even going back for it because my dad having to have surgery and being in and out the hospital.
Let me ask you this. Did you ever provide the location of the children?
Yes, ma'am.
Okay. So because this is your third motion to revoke,
Yes, ma'am.
and the first one, it's,
They're still in the same place with my mom that they've been the whole time because of my dad's health being up and down and us relocating. I didn't want to move my mom and them, to one county when we're moving in the middle
tell
of,
probation you were moving,
no, ma'am.
all right? Because the first motion to revoke,
Right.
it was you were to provide proof of residency in Austin
Right.
and follow through on your CPS requirements. Did you complete CPS?
When I contacted them, when I got out, they said that the case was closed and there was nothing else for me to complete or do with them.
All right. Did you do felony drug court in Austin?
No, ma'am. I actually never ended up leaving. They had, my probation officer that I had went on, I don't know if it was a vacation or what. She ended up not coming back, and I had got like a new probation officer. So I never even got to actually leave to Austin. They revoked it that time.
All right. Did you complete parenting classes?
No, ma'am, I didn't. With my dad and us moving, I didn't get to start anything. I did sign up while I was in the
So
county waiting.
you've been on probation since September 2021.
Right.
What have you completed?
I haven't got to complete anything else.
Okay.
That's what I'm saying. Now that I'm in more of a stable environment and situated, and my dad a little bit more under control, I would be able to start and do everything that I was supposed to originally do.
All right. The court is finding violations 4, 4, and true. The court is going to grant the motion, find you guilty. Would parties like to speak to time? I know State, you said you're asking for 10 years.
Your Honor, I just think a more moderate sentence would be appropriate for her. She's got a lot on her plate. She's got responsibilities she needs to get back to. I would ask the court to consider a sentence closer to 2 than 10, given the situation.
Right. Court will find you guilty, grant the motion, sentence you to 10 years in the prison. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And counsel, if she would like the therapeutic community, I can recommend that. It doesn't increase the length of time that you're in custody. Would you like that or no?
Yes.
All right. You'll still have to request it yourself. All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
Jackson.
Kenyon Brown. Who's the attorney for Brown? Hi. Hello, Mr. Brown. Oh, I'm doing great. How are you doing?
Thank you.
All right. So today is plea deadline day.
No plea, Judge.
All right. So you're asking for a jury trial? All right. So the court will not consider any plea bargain agreements in this case after today without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right. How long are you all expecting this jury trial to last?
Judge, there's 4 different cases, and I believe they're different instances, so we'd probably be trying the ag robbery first, and there's 4 late witnesses, and then including everything else, probably at least 3 or 4 days.
All right.
The ag robbery?
Mhm. The pawn shop.
Okay, the pawn shop case. Okay.
All right, Miss Ferguson. They say 3 to 4 days.
I would say that's correct. Yeah,
Of course,
that's a
it depends
good, that's a
whether they
good
go to the
estimate.
Judge or jury for punishment, if we get to punishment.
So do you all know the answer to that question?
We will probably go to you for punishment, Your Honor, but 3 or 4 days is an accurate, very accurate
Okay.
estimate.
Yeah, that's, yeah. That's fine.
All right, we'll see you back on December 5th. You'll be brought over dressed in whatever clothing that's at the jail. So whatever civilian clothing that you have there, That's what they're going to bring you over in. If you wish to be attired in something different, you'll have to let your attorney know. If
I
there's,
dress my people, Your Honor.
I know you do.
Okay.
I have seen where that has not happened, but not with you. So if there's an issue with the clothing exchange, just let the court know.
And I have to let the court know that last week, another court set a case for the four. I'm
Is it
actually
misdemeanor
in
court?
impact, no, in felony impact. And on a child sex case, and I'm also set that day on a aggravated assault with a deadly weapon set on that day. So just so I'm keeping everybody apprised.
Oh, no, I
if
appreciate
I'm
that.
not able to be here on the 5th.
We will see where we are.
Okay, thank you, Your Honor.
All right, thank you. Is there anything else?
No, Your Honor.
All right, you're excused. Is the attorney here for Kevin Owens? Jason, do you have your parties for?
Yes.
All right, then we'll take that up. Mariana Barnes,
Judge, I did talk to the victim's mother. She is coming in right now. She may try to voice
Okay.
her opinion.
No
Just
problem.
want to let you be aware of that, so that this not to disrupt the proceedings. She wants you to read the letter before. I told her no.
okay. Are you in agreement with me reading the letter before?
No,
Okay. All right, and then there's a Huffman in the waiting room.
That is with Raya Huffman. That's his mother's mother,
Okay,
and that's with Carl Alexander.
okay. All right, court is calling 2023 CR 7666 and 2023 CR 7845, State of Texas versus Mariana Barnes. We're going to have parties announced for the record for the state.
Jason Garahan, Your Honor.
John Young for the defense.
And are you Miss Barnes?
Yes, ma'am.
All right. And Miss Barnes, I know you were late for court, but the court is excusing that lateness because of the weather and because she did call in to the clerks to let them know that she was stuck in traffic. And I know that some people had issues getting to court.
Did you know that there was a tornado over off of 281?
Well, they told me there was one downtown as well. I missed it.
Missed me.
All right. All right, you entered a plea of no contest to kidnapping on October 17th. We're here for sentencing. Are both parties ready to proceed with
We
sentencing?
are, Your Honor.
All right. Is there any evidence you wish to present
No, Your Honor, we request the court to follow the agreement.
and defend? I'm sorry, and state?
Yeah, yes, Your Honor.
All right, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served, take in consideration 2023, excuse me, I'm going to have you sit in the court. 2023 CR 7845. And there's to be no contact with the complainant. All right, is there anything else with regards to sentencing?
No, Your Honor.
Not for sentencing, Your Honor, but just off the record.
Okay, show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know you say you have a child and your child is young. You're going to have to start making better decisions. I read the police report and it appears that everybody was using drugs. Using drugs and having a child does not make for a good life for a child. You understand?
Yes, ma'am.
All right, good luck to you. Is there,
Victim impact, Your Honor.
all right, is there a letter that I'm being asked to read?
I don't, well, let me check, see if she wants to read it or. Yes.
Yeah, let me take this up and then Shannon, whenever you're ready, just approach the clerk and let them know. All right. There's an application.
Your Honor, there is a new plea where we are opposed and asking the PSI. So we're asking for the sentencing for the MTR to be set the same as the PSI.
All right, so is there going to be a plea of true in the MTR?
There is, Judge.
All right, so we're going to take up the MTR and then we'll take up the plea.
Yes, ma'am.
And your date is going to be December 15th to come back.
Understood, yes, ma'am.
All right, court is calling to, excuse me, could somebody take care of the person who's causing issues outside the courtroom? All right, thank you. If you will have her leave the courtroom. All righty. Court is calling 2022 CR 11171, State of Texas versus Fabian Cardenas. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Sir, do you bar for Mr. Fabian Cardenas?
And are you Fabian Cardenas?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Fabian Lee Cardenas who was placed on deferred adjudication for the offense of evading arrest detention with a vehicle on April 3rd, 2023 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, about the 6th day of May, 2023 in Bexar County, Texas, the defendant Fabian Lee Cardenas committed the offense of endangering child in violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
State waives the other conditions, Your Honor.
any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Your sentencing will take place in that cause number on December 15th. Next, we're going to proceed in cause number 2023 CR 9773W. Going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to, counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor, and we did.
Court will find that the state is in compliance with discovery, showing you what's entitled application for community supervision or deferred adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State, are you proceeding on the information as presented?
We are, Your Honor.
Going to show you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're going to be charged with the offense of injury to a child recklessly as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility, and up to $10,000 fine? Did you understand?
Yes, ma'am.
All right, I'm just being told that your date is going to be December 14th instead of the 15th.
Understood, yes. Ma'am. And Your Honor, briefly, I know that it's all in the documentation there, but Your Honor had said injury to a child. Our understanding is it's endangering a child is the.
Oh, I'm so sorry. It is endangering the child.
And he was aware of that.
All right, so the charge is endangering a child. Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, to both.
Mr. Cardenas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the state is requesting that your punishment be assessed at 2 years in the state jail facility, and they are opposed to your application. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
Yes, Your Honor, state offer states, or I apologize. Yes,
All right, showing you the waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it
Yes, ma'am.
in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then to the offense of endangering a child, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
yes, Your Honor. State offer states 1 and all attachments.
No objections, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and all right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt as you've applied for deferred adjudication. We are going to come back on December 14th. At that time, the court will make a decision on your motion to revoke and also on whether or not to grant you deferred adjudication or probation. I'm going to order a PSI. Is a TAP evaluation needed?
I don't know that it is, Your Honor, but if it helps the court with any information.
All right. Based upon what I reviewed in the police report, I'm going to order a TAP evaluation.
Understood, Judge.
All right. Is there anything else?
Nothing further. from
All right.
defense.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
Are y'all ready on snips? All right, and any file that I don't currently have now, you are gonna have to come back on a different day. So I have Kevin Owens, Ernest Morales, Uriah Huffman, and Norma. They'll have to come back in the afternoon. Those are the cases that I have. Court is calling 2023 CR 5651, State of Texas versus Shalise Schnitz. Am I pronouncing your last name correctly? All right. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense
Shannon Locke for Shalise Schnitz.
and,
It's Mr. Javier Garcia.
All right, is he on the case as well?
Yes.
All right, you want to announce for the record?
Javier Garcia, Your Honor.
All right, so I have several motions before me. The first is the motion for defense to conduct an independent analysis of the defendant's blood sample. Did y'all review that?
So we took a look. My understanding of that motion is that defense wants to get the second vial of blood taken by BCSO in this case and send it through their own lab. I mean, the state has no objection. I think that's something that they have the right to do.
Okay. All right, that will be granted. And of course, the laboratory here will have to make safeguards, and that's not in the court's purview to make safeguards for the analysis.
Right, Judge. My understanding is that the defense will have to, whoever is analyzing the blood for them will have to pick up the blood from BCSO, and there will have to be a clear chain of custody. So that's something that they're going to have to do.
That's correct, Your Honor.
That the safeguards are in place.
Quiet, please, in the courtroom.
All right, everyone, you need to whisper. All right, and then the motion to expect, examine, and test physical evidence.
My understanding, Judge, is that the defense wanted in that motion to take a look and inspect the vehicles that were involved in this case. My understanding is that they are in the Bexar County, they're in Bexar County's possession. So that's something that we can try and facilitate. It's just coordinating everything with everyone. I know that the detective can multiple us inspect, he has to be there.
All right, so do y'all still want to keep number one where it says that you are to produce the vehicles? Because I don't know if that's the proper wording.
Just make available to us for inspection, Your Honor.
All right, if y'all want to put in there to make available for inspection instead of produce. All right, that will be granted. And then there's a request for no broadcasting. Is that correct?
That is correct.
All right, so the court has read the defense's motion, and what I can tell the defense is, number one, the court limits the number of people in the courtroom for security reasons, also for health reasons. I think everybody is aware of the brawl, for want of a better word, brawl, skirmish, or whatever that occurred in the other courtroom. As everybody is aware, there are only a limited number of deputies. I have 2 deputies in this courtroom, and we almost had another incident here today that I think would have turned quite differently if the courtroom were packed. The court must have an open courtroom to the public, and that is how the courtroom is keeping it open to the public. So I've read your motion, and that motion is denied.
Your Honor, may I make a little bit of a record on that?
Sure.
Okay. And so Ms. Schnitz has some specific things that have affected her as a result of the broadcast over YouTube. And specifically, Your Honor, the open courts, one, we don't think that you need to close the courtroom to non-participants. So we object to the closing of the courtroom, which we were just made aware of this morning. So we have that objection. We think the courtroom should be open to live audience members. Ms. Schnitz is in a very particular situation. She's in a custody battle at the time, currently, and her ex-husband monitors these YouTube videos. He saves them and broadcasts her information to her friends and family and uses it in her child custody case. Additionally, Your Honor, sorry, I'm going to have Ms. Schnitz speak to that if she could.
Sure. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Shelley Schnitz.
All right, thank you. You may question.
Are you concerned about being broadcast on YouTube?
Yes, I'm very concerned.
And can you tell the court why?
I'm very concerned because my ex-husband, the husband of my daughter, who is,
I'm sorry, the father of your daughter?
oh, the father, I'm sorry, has been, he is being investigated currently for abuse of her sexual assault and numerous counts, a very, very serious situation. And he is using the YouTube videos, and he's explained that in emails to watch what is happening on court to find the location of my daughter. And I'm sorry.
So also, he would come in person before, correct?
Yes, sir.
Okay. And now he knows where you are because he can watch the broadcast. Is that right?
Yes, ma'am.
Oh.
I mean, yes, sir.
And when you additionally, you've had to talk about your treatment situation. You're addressing your alcohol issue. We've had to do that in open court previously. Is that right?
Yes, sir.
And has he recorded those to your knowledge?
Yes, he records those as well.
And he lets other people know who are involved in your case?
Yes, he lets over 20 people know and places it on social media and sends it out.
Okay, and that's everywhere from Governor Abbott to Joe Gonzalez to everybody that is also the principal of your daughter's school. Is that right?
Yes, sir.
Okay. And so at this point, you're left with a choice of either terminating these proceedings by entering a guilty plea or continuing to be broadcast on YouTube.
Yes,
Okay, and that's the choice that you're currently facing. Is that right?
yes.
Okay. All right. Do you want to be broadcast on YouTube?
No, sir. It's very scary for me. Terrifying.
No, that's all right. I have no further
Any
questions.
questions?
Nothing to say, Judge.
All right, and the court will state again, everyone is aware of the brawl, skirmish, whatever you want to call it, that took place in this courthouse recently. No less than, I think, 10 deputies or maybe more were summoned. There was a fight in the jury box where audience members came from the audience and attacked someone. And I will use the word allegedly, but I think everybody has is aware of it. An inmate that was in the box. We just had what could have been a bad incident in this court today, where deputies had to step in and escort somebody out of this courtroom. This is a court that needs to be open to the public. I am not going to allow people in the courtroom for safety reasons. I'm not allowing people in the courtroom unless they are a defendant, a person accused, or unless they are a witness, and those witnesses will be brought in when they are needed. The state will tell you, and other persons in this courtroom will tell you, anyone who is given victim impact, they can come in when it's time for them to give victim impact. But that is the way this courtroom will be run. So for security issues, we only have 2 deputies in a courtroom, and we have a third, sort of a third. And I say third because he's wearing his jacket, right? But he's not assigned to this courtroom. So when you think about it, right now we have 1, 2, 3, 4, 5 people in the box. And really normally only 2 deputies. And sometimes we have 10 people in the box. So the motion is denied. And we're going to come back
And Your Honor,
on December 12th.
just one other question. Could you admonish people not to record the broadcast?
Oh, people, I am not in charge of broadcasting.
So what happens is people will capture, like they'll capture this event, they'll put it on other platforms.
And what I can tell you, counsel, is in this courtroom with your client, I have never asked, nobody's ever asked, if I'm wrong, tell me I'm wrong. Nobody's ever asked what school her child is at or asked any of that nature. With regards to a civil case, that's something that needs to be addressed civilly. This is a criminal court.
But what happens, Your Honor, and the problem is that this is now, the YouTube broadcast is as much an official record as the court reporters.
No, it's not. The court reporter's record is the official record. I made my ruling. You all are coming back on December 12th. On December 12th, I expect everyone to have their discovery in order. If there's more time that's needed to look at a vehicle, let the court know. If there's some issues with the blood, let the court know before the December 12th setting. All right, Ernest Morales.
Thank you, Your Honor. Can we be excused?
Yes, you may be excused after you sign the reset form.
Thank you very much.
And on Ernest Morales. Yes, are you all ready to proceed?
No, Judge, I let the clerk know, I got a text message this morning from Sarah May. She hasn't completed the Padilla letter. She did have an interview with Mr. Morales.
Okay, all right, Ms. Ferguson, I need a reset because they haven't done the Padilla letter isn't completed.
They can come back on November 30th.
Yes,
Your Honor, like I was telling my lawyer, like I did have an interview with the other lawyer. I want this to be done today. I mean, I already know the process. I already know what could happen if I'm found guilty or whatever, you know what I mean, that I could get deported, you know, just like I told the lawyer, I'm okay with it, you know what I mean?
All right, I understand what you're saying, but let me just tell you the position that the court is in. This is the position that I'm in. Legally, when someone is not a citizen, they have to be advised by an immigration attorney. I know you say you know what will happen, but that's not the way it works in legal world, because if I were to go forward with this sentencing, even though you're saying, I know what's going to happen, you know what would end up happening? If you decided to change your mind, you could come back and guess what? We would have to start the whole process over again. And guess what they would say? Judge Boyd, you know that person has to be advised by an immigration attorney and you did not do your job. So
I was advised. I had an interview with the lady yesterday, and I told her, you know what I mean, like it'll be okay. You know, she said okay that she was gonna.
Yes, but there's case law on file that says that there has to be a appeal letter on file, and she hasn't had sufficient time to prepare for that. She worked for the public defender's office. She has a lot of different cases, and I'll explain that to you.
Then why would she tell me that she was already gonna be ready? You know what I mean? Like, because I told her that I didn't want this to expect tomorrow's date. You know, just today. You know, why would she tell me like it was gonna be done?
all right,
You know what I mean?
I understand what you're saying.
And now I'm here in front of you, you know, and
Here's the thing. I understand what's going on. I understand your confusion. Let me ask you this. How old are you?
I'm 42.
All right, you're 42. This is what I would always tell people. When you're dealing with children and you make a promise to a child, you need to keep that promise because they don't understand when other things come up, but we're adults. So I want you to internalize the fact that this case is not going today. And the reason why it's not going today is because of legal reasons. Do you understand?
Yes, Your Honor.
So your attorney, she could say, Judge, I want to go forward now without that information. And you know what I would say? Not doing it. And you know why your attorney is not going to say she's going forward without that information? Because guess what? That would be called ineffective assistance of counsel. And if you decided to come back later on and want to do an appeal, guess what? It will be granted for those reasons. So we'll see you back on the 30th. If she has it before the 30th, let the court know.
Yes, Judge, I will. I'll ask, I'll try to get it.
All right, thank you. Huffman. And then after that, we have Robles, Martinez, and Owens, and everything else will come back the afternoon.
Judge, we do, just if you have a moment, that Rose, my advocate's getting the victim and his mother.
Okay, and then I will let Ms. Huffman, she's on Zoom?
Yes, ma'am.
All right,
No objection.
all right, thank you.
I'm
Yes, I'm having her Zoom in.
gonna apologize for any of my sniffing or coughing, Judge. I have a bit of a sinus infection. I tested myself. I'm free of the nefarious virus.
All right. You know, I just got my flu shot and whoa.
This is a yearly occurrence with me. Like, I know the feeling all too well.
All right, Ms. Huffman, are you able to hear us?
Yes, I can.
All right, so Ms. Huffman, this is the way this proceeding is going to work. You're not allowed to talk until someone actually calls you as a witness. You understand?
Yes, ma'am.
All right, so if you'll place yourself on mute for me, please.
Okay, how do I do that now? Oh, okay.
All right, court is calling 2022 CR 7209, State of Texas versus Uriah David Huffman. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Carl Alexander for Mr. Huff.
And are you Mr. Huffman?
Yes, ma'am.
All right, you entered a plea of guilty on September 11th. You applied for deferred adjudication. According to the plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There are 2 cases that are being taken in consideration. There's an affirmative finding of deadly weapon, a $5,000 fine, and the state is opposing your application. And there is restitution to Joshua Sandoval and Ramon Lavario. Have both parties had a chance to review the PSI report?
Yes, Your Honor, the state has.
Yes, Your Honor.
Any objections?
There's a few corrections, Judge, but I think we can handle most of that during testimony.
All right. State, do you have any witnesses?
Check one second. The statements. Witnesses.
All right, defense, do you have any witnesses?
Yes, Your Honor. Okay. I guess first I'll go ahead and take care of the Zoom witness called Candy Huffman.
All right, can you unmute yourself, please? All right, any objections to the witness appearing by Zoom, state,
No, Your Honor.
defense?
No.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. State your name for the record, please.
Candy Joanne Huffman.
Defense.
Thank you, Your Honor. Ms. Huffman, although I think we can tell by your last name, how are you related to Uriah?
I'm his mother.
And how old is Uriah?
26. Oh God.
Have you not seen Uriah in a while?
No,
Where do you currently?
I also have lupus, and so memory and stuff is a little, I had to think about the math.
I got you. Okay. Where do you currently live at?
I live in Florida,
Can you be a little more specific, at least what county?
Orlando. I live in Orlando.
Uriah, he's originally from Texas, is that right?
Yes, he was born in Dallas.
And was there a father in his life?
No,
Has he ever known his father?
no, he's never met him. He left, rather I left him when his father, whenever I was 4 months pregnant.
Does your son have a drug problem?
He did. Yeah,
And you say he did, are you talking about the fact that he's been sober since he's been in jail for a year and a half?
yes, I suppose.
Okay, so prior to his arrest for the offenses that brings him here today, how bad would you say Uriah's drug use was?
I would say probably pretty bad. As far as what I was aware, he was always high.
Did he choose to be homeless in order to feed that addiction?
I think that I don't think he chose to be homeless in order to feed the addiction, to be honest. I think he chose to be homeless, and the addiction, or the drug use rather, was just part of it because of the people that he was around.
So during this time, the time that Uriah took part in hurting people, was he the same Uriah that you knew and raised?
No, absolutely not. Uriah was never violent. Even whenever I found out about what happened, I was shocked. He's not a violent person. He was never in fights at school growing up. He never at all. He wasn't violent at home. He didn't punch walls. He was never like that, ever.
Now, since his incarceration, have you had contact with him, either through
Yes.
phone, video visits?
Yes.
And have you seen Uriah change over the course of the last year and a half?
Yes, other than just being understandably sad and depressed and lonely, as you would be in the situation that he's in, I got my son back. he's became, I could talk to him again. He could carry on and wanted to carry on a conversation with me. He was back to being my loving son again.
Now, if the judge grants Uriah deferred adjudication, okay, will he have a place to live?
Yes, he can live here with me.
So that would be in Florida.
Yes, sir.
And again, if he's granted deferred, there's probably going to be a lot of requirements of him, such as making appointments, being tested for substance abuse, probably doing some type of classes of community service.
Mm-hmm.
Will you aid him in making sure he's complying with all of the requirements?
Absolutely. Yes. I work from home. Well, I am starting a home business. I'm an artist, so it's just crafting, but so I'm free to do that.
Will you help Uriah in getting employment?
Yes, absolutely.
Does he actually have a job waiting for him in Florida if he is granted probation?
Yes. My husband had spoken to but he told me, now this was a while back, that he, sorry, my hand is cramping, that he could have an entry level position with my husband.
And what would he be doing?
Just computer work. I'm not really sure exactly what it is, but it would be just stuff on the computer. Other than that, if that isn't still available, because he hasn't talked to his boss about it recently, then, you know, I would do whatever I needed to do to help him find a job. That would definitely be a priority.
And again, if Uriah is granted deferred adjudication, he's very likely going to have to make restitution to the victims of his cases. Would you help him make sure that he stays employed and he's making good on that debt?
I would do whatever I needed to do to help him do what he needed to do. Yes. My husband and I would, my mother and father would. I've already talked to them about it as well. My mother and stepfather also live here. That's why I moved here. And they're also supportive. So
that's a support structure that Uriah has there in Florida. Did he have all that here before when he chose to get lost in drugs?
He's always had me, but no, not really. Other than me, no.
But so now it's a bigger support structure waiting for him.
Yes, I would say so. But he also he won't know anybody here. Like nobody from, you know, anybody that he used to run with or know on the streets or anything. Like he won't know anybody here. So it would be a complete fresh start, you know, and as far as that goes, I think that would be a great help as well. And that's just my opinion, but yeah.
All right, Ms. Huffman. Thank you for your time. I'll pass the witness.
I'm sorry, state.
Thank you. Ms. Huffman, I'm Jason Garahan. I'm a prosecutor for the state of Texas.
Yes, sir. Hi.
Hi. Nice to see you on Zoom here. I got the indication that you're, when Mr. Alexander was asking you some questions, that, tell me if I'm wrong, but Uriah's violence towards other people was sort of a drug induced. Is that what you feel?
Yes, I think that it was drug induced, and that and because of who he was with, more than anything.
I mean, you are aware that there's a evaluation, what we call a precedence investigation, where your son stated that he denied consuming alcohol or drugs during the commitment of this offense of aggravated assault on an individual. Are you aware of that?
No, I'm not, but I know how methamphetamines work, and I know my son, and he wasn't the same person at that time
Were you there?
mentally.
Sorry.
No, I wasn't. I obviously wasn't there, but I talked to him often. Well, sometimes I went and talked to him for a month or two, but I mean, I talked to him that day, the day that he got arrested, and I could hear it in his voice.
Did you know that if he actually didn't get arrested on the day of the offense?
No, well, no,
In his precedence investigation, he said he did meth after the offense happened in the days following. You're not aware of that, are you?
no.
And are you aware of the victim's injuries in this case?
The victim's what?
Injuries.
Yes,
So you're aware that he lost an eye,
yes,
his skull was crushed in,
yes.
and that he was shot at more than once.
Not by my son. Not to, I'm sorry. It doesn't matter. Yes, I am. And it's a terrible thing. And I'm glad that he is alive.
You're also aware he was stabbed. Is that correct?
No, I wasn't aware of that part, but I mean, it doesn't make it any better or worse. It's all bad.
You realize also that he was hogtied with his arms
Yes.
and his behind him
Yes.
and put it in his own trunk of his own car
Hmm.
and driven around and then dumped on the side of the road without many articles of his clothing, pretty much naked. Are you aware of that?
Yes.
Your son told you this?
No.
Okay. No further questions, John.
All right, any further questions? All right, you can call your next witness. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Uriah David Huffman.
All right, make sure you keep your voice up.
Yes, ma'am.
All right, defense.
Thank you, Your Honor.
All right, Uriah, you had a chance to go over this PSI. I'll just start there. Right.
All right, you're gonna have to answer yes or no.
Yes, sir.
Okay. And I believe you said there's a couple things you wanted to comment.
Yes, sir.
Okay. So let's just cut right to the chase about what happened to Joshua. You know, he's here to go. Right.
Yes, sir.
The PSI talks about you actually tying him up. Did you tell the probation officer you actually tied him up?
The probation officer?
That interviewed you for this. Did you tell them that you tied him up?
I don't believe so.
Okay. So as far as the tying up is concerned, because he was tied up, right?
Yes, sir.
Okay, how did you participate? What was your active role?
I just got the rope.
Okay.
And I handed it to DK, or to Daryl, sorry.
I'm sorry, could you speak up?
I got the rope and I handed it to Daryl.
Okay.
And that's your co-defendant in this case, who I believe you referred to as DK.
Yes, sir.
The PSI also talks about you putting Josh in the trunk of his car.
Yes, sir.
Did you do that?
No, sir.
Did you tell probation you did that?
No, sir.
Did you drive his car away with him in it?
Yes, sir.
The PSI also talks about when you guys went and stopped somewhere in Atkins, and it makes it sound like you took part in the shooting, like that you actively shot Joshua. Did you tell probation that?
No, sir. I mean, I told them that I was there, yes, but I never touched the gun. I never did anything like that.
Did you assist in removing Joshua from his trunk so that he could be shot?
I don't believe so, no.
Did you have a gun?
No, sir.
So are you the one that shot Joshua?
No, sir.
Who did shoot Joshua?
Daryl shot Joshua.
Now, You're not saying that you didn't participate in what happened to Joshua, are you?
No, I'm not saying that.
And I believe what's actually in the stipulated evidence is earlier that day, Joshua had actually hit you in the face with a guitar. Is that right?
Yes, sir.
And so you made DK aware of this?
Whenever DK pulled up to the trailer, he asked me why I was bleeding, and I told him that Joshua hit me with a guitar.
Okay. Did you ask DK to do anything to Joshua?
No, sir. He walked in and started doing that on his own.
Okay. But once DK started doing things to Joshua, you made a choice, right?
Yes, sir.
You chose to go get the rope.
Yes, sir.
You chose to drive the car.
Yes, sir.
And you chose to plead guilty as opposed to no contest, right?
Yes, sir.
So probably the biggest question in the back of the judge's mind is, based on everything that happened to Joshua, okay, and which you did participate in,
Yes, sir.
why in the world should she give you probation and not just send you to prison?
Because I understand that it was wrong in not calling the cops and participating in any of it. And I believe that I can prove that that's not who I am, and that I'll be able to complete probation and pay back any kind of restitution that goes to them, to Joshua.
Are you sorry for?
Yes, of course.
happened?
I'm sorry that all of it happened to him. He didn't deserve it, and I'm sorry to his family.
Well, they're right there. So you think maybe you should tell him and not us?
Of course, I'm very sorry that all of it happened to Joshua. If I could go back, I would have called the cops. I would have tried my best to convince DK not to do it. I'm very sorry.
You had an evaluation about your drug usage.
Yes, sir.
And I think it says in there you were using meth daily. Is that accurate?
Yes, sir.
Okay. DK wasn't just your friend, right?
What do you mean?
DK was selling meth.
Yes, sir. He was, yeah.
Okay. And all the people you were associating with at the time, including Josh, you guys were all meth users, is that right?
Yes, sir.
Again, if the judge takes a chance on you, that's a hard thing to shake. It was recommended that if you're granted probation, that you do inpatient therapy.
Yes, sir.
Excuse me, rehab. Are you willing to do that and do what it takes?
Yes, sir.
No matter, because there's several programs the judge could choose from, some of which could take up to a year before you're ever released.
Mhm.
Are you willing to do that?
Yes, sir.
Are you asking the judge for a second chance despite your choices?
Yes, sir.
Tell her that, not me.
Yes, ma'am. I would. I hope that you'll give me the chance and opportunity to prove that, or to give me a probation and even the drug rehab program.
I'll pass my Mr.
State.
Yes, Your Honor. Mr. Huffman, you said you didn't actually actively shoot. Mr. Hannibal, right?
Yes, sir.
And you actively, I guess, grabbed a rope, handed it over to DK, which is Daryl King, right?
Yes, sir.
Daryl King's the one that shot Josh, is that right?
Yes, sir.
Who stabbed him?
I'm not aware.
You're not aware? You didn't have a knife?
No, sir.
You didn't have a knife.
No, sir.
And so the stab wounds, you don't know how that happened?
I'm aware that he got stabbed, but I don't know.
Who
how.
stabbed him?
All right, I'm gonna need you to speak up.
I'm aware that he got stabbed, but I'm not aware of who stabbed him.
Was there anybody else?
Was there anybody else that could have stabbed him?
Mhm.
Yes.
Who?
I don't know his name. It was just a guy.
So you don't have the guy's name.
No, sir.
So this random guy that you don't know his name stabbed Josh. Is that what you're saying?
No.
So who
I'm
stabbed him?
saying that there was another guy that could have done it.
Could have done it. So you could have done it.
No, that's not what I'm saying. You asked me if there was anybody else.
Okay.
Yes, there was.
You were there.
Yes, sir.
You were there when he got put in the trunk.
Yes, sir.
You were there when he got tied up.
Yes, sir.
You're the one that drove the vehicle around, right? In a hot trunk. And you knew that this individual had been stabbed, beaten, and tied up
No, at the time, I did not know.
You
I
didn't know he
found
had been
out,
beaten?
no, that he'd been stabbed. I didn't find that out until I was already in jail.
Oh, so you didn't witness any stab wounds. You didn't see him bleeding before he got shot?
No, sir.
He wasn't bleeding before y'all shot him on the side of the road.
I didn't shoot him, but
I know, I said y'all, law parties in the state of Texas, if you're standing there, you're participating, and that doesn't mean you pulled the trigger, but you were there, right?
yes,
And
Yes,
you
sir.
left with DK, right?
yes, sir.
Was he bleeding before you all shot him? Let's just say DK, I'm not gonna split peas with you. DK shoots him, you're standing next to DK. Was he bleeding before he was shot?
Yes,
Why was he bleeding?
yes, I assume he would, I can't tell you why he was bleeding. I'm
You
sure
can't?
he got stabbed, but I don't know who stabbed him.
Did you hit him?
No,
You never hit Josh,
no, sir.
ever.
No, sir.
So DK did everything.
Yes, sir.
So DK stabbed him.
Okay, well, I don't know. I can't say for sure if TK stabbed him.
Okay. So he was bleeding before he was shot, right?
Yes, I mean, I
Hey,
believe I saw.
You were sober. You weren't doing drugs. You weren't drinking. Right? That's what you told everybody in this packet. You weren't drinking and you weren't on meth the day this happened. You said it twice. So you were sober when this happened. Right?
That is what that says, but I've already tried to tell my lawyer that I was using at that time.
At that time. Were you using that day or not?
Yes,
So now that's something else that needs to be changed in this packet.
I thought that's what he said. I'm trying to.
I
make
don't know.
it
I'm
clear to him.
asking you.
Yes, that I was using drugs that day.
So these two items that say right here, it says defendant denied consuming alcohol and using drugs on the date of the instant offense. That means that offense that happened that we were just talking about. That's wrong.
I mean, yes, I did use drugs that day.
Okay. Before or after you all shot him?
So,
Sorry, I
Both?
can't hear you, sir.
both.
So you were using drugs before and after Josh was shot?
I had used drugs before. Yes, and
That day.
yes, that day. Yes, sir.
And then also right here, it says right here, I wasn't consuming alcohol or using drugs.
Yes, that's what my attorney went through with me, and I told him that was wrong.
Okay, so now that part is wrong also. That you
Yes.
were using alcohol and drugs.
Not alcohol, but drugs. Yes.
Okay, all right. So you deny, well, okay, you do remember him being tied up, right? What you call hog-tied, right?
Yes, sir.
And he didn't have his clothes on, right?
Yes, sir.
Why didn't he have his clothes on?
Because they got taken off.
Who took them off?
DK.
And you just stood there?
Yes, sir.
Was he hog-tied at the time that the clothes were being taken off or not?
Yes, I believe so.
He was. And then when was he shot?
He was shot behind the car.
Behind the car? When he was on the ground?
Yes, sir.
Bleeding? Already been cut?
It was
Already
dark.
been stabbed?
Yes.
Tell me this. What do you think had happened to him after he got shot?
He laid on the side of the road.
Well, did you think he died?
Yes, sir.
Okay, so this is one step away from a murder, isn't it?
Yes, sir.
So why do you deserve deferred adjudication on this case? Tell the court that. Why do you deserve it? Because you almost committed murder. You see the man right there with his face bashed in and he has his left eye's not there anymore? Why do you deserve deferred for that?
Can't honestly say that I don't.
Thank
Or
you.
that I do.
Thank you. No further questions.
Defense, any other questions?
And I apologize, right? I did forget to ask you, we discussed it before, so. Did you want to clarify with the court, you were using drugs that day, right?
Yes.
But you weren't drinking?
No, I was not drinking.
You knew what was going on, Joshua. Right? As the events are unfolding, you know what's going on.
Yes, sir.
You could have done something, right?
Yes, sir.
Why didn't you?
I wasn't in the right state of mind.
I just been hit with a guitar. So I wasn't thinking clearly. DK, he told me to get the rope. He told me to do this, and I chose to listen to him. Whenever I should have told him that, no.
What gave DK so much power over you that you
It's not that he had
listened to him?
It's not that he had power. It's just that I don't know. He's a very intimidating person, and
Is DK a little man or a big man?
he's a big dude.
Did you ever know DK to be violent?
He always got what he wanted. Yes,
Or DK was the one holding the gun?
yes, sir.
Yeah, we need to make it clear that you understand. Okay. Even though you're saying you're not the one that shot Joshua. You're unclear who stabbed him. You helped, and the law says you're just as guilty.
Yes, sir.
You get that?
Yes, sir.
Despite that, are you asking the court for a chance to prove that you can change and you can be a productive member of society?
Yes, sir.
Thank you, Rep. Councilman.
No question.
All right, any other witnesses?
No, ma'am.
Any other witnesses from the state?
Nothing to say, Your Honor.
All right, with regards to the restitution amount, is there agreed upon restitution or no?
No, Judge. And if I can address that, we've been provided nothing as far as what these amounts come from. And so I believe, despite if there's proof that we provided, he owes it, he owes it. I mean, but I think we need to have a restitution hearing on that. When it comes to the victim in the instant case. Mr. Lavario, who is the complainant in the UMV case that's being TIC'd. Again, it's a very big number he's alleging with no proof. I will also point out that in the discovery given to us by the state, Uriah is found in this gentleman's stolen pickup, and there are no tools there. He's not found with them or anything. There's also some conflicting statements that he gave. So I would require a restitution hearing on that one as well. But again, whatever he owes, that proofs provided he owes.
All right, this is what the court will do. The court is going to deny your application, find you guilty, sentence you to 12 years in the prison, give you credit for any time served. There's a $5,000 fine, time and money will run concurrent. Take in consideration 2022 CR 7208, 2022 CR 7210. I can order the therapeutic community. It'll be up to them whether or not they place you in the therapeutic community. I absolutely have no jurisdiction over that. So if you would like, I could put that in the order.
Yes, ma'am.
There's an affirmative finding of deadly weapon. There's to be restitution, if any, and no contact with Joshua Sandoval and Ramon Lavario. Going to show you what's inside titled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know that 12 years is a lot of time. Honestly, anytime you do, whether it's at the Bexar County Jail or wherever it's at the prison, that's a lot of time. But I did internalize everything that was said. I listened to all of the witnesses. If you have a drug or alcohol problem, you need to use this time away to get your life in order, to concentrate on what improvements you want to make so you don't be back here. The complainant in this case has permanent injuries, and those injuries will never go away. You can go to jail, do your time, get your life in order. You can even get a college degree at the jail. And I could be wrong, but I don't even think they have to pay for the degree. So you can get a free degree at the jail and work on yourself, figure out how you got in this situation and not put yourself in this situation again. Do you understand?
Yes, ma'am.
All right. Is there a victim impact?
No, Your Honor.
All right. Good luck to you.
Thank you, ma'am.
Thank you, Judge. Maybe excuse.
Yes. No, we'll be back at 1:45. 2 CR 7549, State of Texas versus Devin Strike. Could I have parties announced for the record for the state?
Jason Garrett.
Vince?
Adam LaHood for the defendant, Your Honor.
All right, and are you Devin Strike?
Yes, ma'am.
All right, you entered a plea on September 5th of no contest. And there was a request for a PSI and TAP evaluation. According to your plea bargain agreement, the state is recommending deferred adjudication. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
All right, any objections to the PSI report?
No, Your Honor.
No objections. Just one question. They said a DDRF and mixed screening was set for, I believe, today, say the 26th.
Yes.
I didn't know that was done. That's, other than that, it's not an objection, Your Honor. I was just curious if it was completed.
No, if it's scheduled for today, it's not completed.
That would make sense.
Yeah, no problem. So have you had a chance to review the TAP evaluation as well?
I have, Your Honor.
Any objections to the TAP evaluation for either party?
No, Your Honor.
Nothing in the public defense, Your Honor.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. We're here. Mr. Strike, he took responsibility for the action. He acknowledges he messed up, Judge. We're hoping the court will grant him deferred. Obviously, he completes it, have a very good outcome for him. Let him avoid a felony record and felony conviction for the rest of his life. He messes up, he's facing up to 2 years in state jail, which is day for day. He understands how serious this is, Your Honor, and respectfully would ask the court to follow the plea and grant him deferred adjudication today.
All right, Mr. Strike, is there anything you wish to say?
No, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Devin Strike.
All right, do you have any support system, family, or are you just on your own?
I have a support system.
I'm sorry, who?
I have a support system.
All right, who's your support system?
My mom, my girlfriend.
All right, do you live with your mom?
No,
Who do you live with?
my girlfriend.
All right, and how old is she?
I'm 28,
All right, and how old are you?
21.
All right, do you all have children?
Yes, ma'am.
All right. I remember this case. That's why I asked you that. So if you're drug tested today, what are the results going to be?
Negative.
All right, when's the last time you used?
Never. Well, not never, but a long time ago.
Well, I mean, you're, so you're saying that you haven't used and you were not using the drugs that you're here for today?
Mhm.
You're gonna have to say yes or no.
No, ma'am.
Are you employed?
No, ma'am.
So you're not supporting yourself.
No, ma'am.
So how are you surviving? And when I say surviving, if you don't have employment, you have to eat, you have to drink water or drink something, you have shelter, obviously. So how are you supporting yourself? How do you eat? And when I say how do you eat, how are you getting food?
My girlfriend.
All right. And how old is the child?
She's 5 months.
And is she in daycare or what?
No.
So where is she now?
At home.
With your girlfriend?
Mhm.
Okay, you need to say yes or no. And does your girlfriend work?
Yes, ma'am.
And what does she do?
She works from home.
Why don't you have a job?
Because I'm waiting on a disability check to see if I'm qualified.
All right, have you put in for disability?
Yes, ma'am.
And what's your disability?
I have schizophrenia.
Okay. All right. Did anybody see whether or not he would be a good candidate for mental health court? Was that even looked at? And the reason why I'm asking, I see his criminal history, but let me just tell everybody what my concern is. My concern is, obviously there's an issue with him staying on his medication. We have a 5-month-old at home. The girlfriend works. I'm not saying anything will happen with a 5-month-old, but I think we all know things can happen with a 5-month-old if you have somebody with schizophrenia. And I do not have the support to monitor him the way mental health court would monitor him, or to monitor him, with probation. They can only do so much because they have a heavy caseload. And if he's in mental health court, they can do more. So that's my concern. So I don't know if anybody else has those concerns. I don't know if anybody wants to see if he would be accepted in mental health court.
What would be involved in that, Judge? I'm not too familiar with the process.
Oh, they report weekly to mental health court.
Okay.
They would probably get a case manager, which he needs a case manager to make sure he stays on his medication. Are you on any medication?
Yes, ma'am.
All right. Do you have a case manager?
No.
He needs a case manager to make sure he's taking his meds. And this has just been my experience in having clients who had mental health issues, is that they start feeling great, then they stop taking their medications. And the reason why they stop taking their medications is because there are side effects, and they don't tell their doctor about it. And then the next thing you know, my client will be back in court for another criminal case because they're not on any medications. So that, coupled with he's trying to get SSI for his mental health issues, the mental health court would have people that would be able to help him with that. So I don't know if you all want to discuss that. I don't know if, based upon his history, state if you want to consider that or not.
I haven't looked at his history of late, Your Honor.
All right, well, what I see on this is there was a misdemeanor assault case, evading to detention, and he received probation for both of those, and probation in the assault case, and it was dismissed, I'm assuming because he completed probation. And then the evading arrest, his probation was terminated. And then resisting arrest, probation was terminated. And then we have this.
Yeah.
So I don't know if y'all want to look at that. I don't want to set him up.
Well, the state wouldn't be opposed to this.
Okay, because I don't want to set him up for failure.
We're not opposed, Judge.
All right, so if you will go, Ms. Ferguson, can you see if they can do a referral for mental health court for him? And then we'll reset it, do a referral for mental health court. And then if he's accepted to mental health court and you all want to do a motion for new trial, we'll hear it. And if there's no objections, then, because they don't accept you if you have
A plea.
any case, yes.
Okay.
All right, Adam, if you will wait, Mr. Strike.
Hold on.
Hi. So do you understand what's going on?
Not completely,
All right, so
I'll talk to
you'll
him.
talk to him?
Yeah.
All right, and if you could tear up the trial court certification for me.
But you're good. So, have a seat. I'll talk to you.
And Vashawn, does he still have the MIC evaluation scheduled today or no?
Yeah.
Okay. All right, can you let them know that he was here? Yeah, we'll see if they'll accept him. No, felony. Because this is a possession less than a gram. Isn't that what he pled to?
I got one, right?
Yes,
It was a possession less than a gram.
yes. With Judge Rangel. All right. All right. But we've had a couple of people who end up at. Yes, yes. Yes, yes. All right.
All right, so
Yes, okay. Because we're all on the same page.
Yeah.
all right, so where do I need to go?
Okay. And And Norma, what date do you want to bring this back? Yes, we can. And if he's accepted before then, just let us know.
Yeah, definitely. So is it kind of like the misdemeanor one, or if they're accepted, then that's it, basically?
Yeah, then they will go there.
Good deal.
Yes.
Well, yeah, lots of good motion for new trial.
I just like that.
So this is the 379.
We really don't have the support staff for what he needs, because he would really need to see somebody on a weekly basis to make sure he's on his net. And he really needs a case manager for that.
And it's still on.
Mhm.
Yeah.
Oh, it will go there. And the only time they come back here is if they are kicked out of the program, or either they graduate. If they graduate, I go to their graduation.
Kids keep growing.
Yes, there is. Oh, Caroline, I'm sorry. Chandler?
All right.
Okay. All right.
I'm just working on the dismissal forms, Judge, for, I mean, not for the whole thing, but we're gonna TIC some cases as part of our agreement, so that's the only thing.
Yeah. Okay, so we're not gonna hear the rest?
Not that I know. I mean,
Oh, okay.
All right.
We're ready, Judge, sorry.
All right. Did you all do a trial court certification?
I know that's all.
Oh, it's over on the wall.
Wild grasses and all. Everything is nice and good.
I really,
Kind of depends on the weather's doing. Yeah, Raggy was got I'm taking these. And the mold slide. I'm. Where do you? I should learn. But. I just asked.
All right, thank you. Court is calling 2022 CR 2006 State of Texas versus Christopher Ryan Chandler. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
John
Defense.
Robertson for Mr. Chandler.
And are you Mr. Chandler?
Yes, ma'am.
Right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Christopher Ryan Chandler who was placed on deferred adjudication in 2022 CR 2006 for the offense of evading arrest detention with a vehicle on June 16, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
This is on the supplement, Judge. It's
Just 1 second. I don't have a supplement. All right, I'm going to show you what's entitled State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that as well, Mr. Chandler?
Yes, ma'am, I did.
And did you understand it?
Yes, ma'am, I did.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Christopher Ryan Chandler, did then and there fail to report to the supervision officer as directed for the months of February, March, April, May, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
State.
Your Honor, we waived the other violations alleged in the motion to enter adjudication.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am. I was.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor.
Your Honor, we're asking, the defendant is, we're asking you to adjudicate the defendant guilty. We're going to dismiss the underlying violations alleged in the original motion to enter adjudication of guilt, and 4 years to do, Your Honor.
All right, is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will grant the motion, find you guilty, sentence you to 4 years in the prison, give you credit for any time served, all right, is there anything else with regards to sentencing?
Yeah.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. How old are you?
24.
You're going to have to start living your life better. Otherwise, you're going to find yourself in and out of the prison. You understand?
Yes, ma'am.
Don't be that person who's the oldest person at the prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
So can I first later with you?
Sure. All right, who's here on Megan Wilhite? Hello.
Good morning.
Yes, ma'am.
All right, the court is calling 2020 CR 2272, State of Texas versus Megan Hayes Wilhite. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Kelly Piddle.
And are you Megan Wilhite?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am. Will Height.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did
Yes,
you
ma'am.
understand them?
Yes, ma'am.
Are you the same Megan Hayes Wilhite who was placed on community supervision in 2020 CR 2272 for the offense of burglary of a habitation force on August 29, 2022 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, did then and there failed to report to the supervision officer as directed for the months of April, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, miss.
And Judge, it's going to be on the first amended motion to revoke. It's violated condition number 1 on or about the 26th day of September 2023 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True, miss.
Your Honor, state waives all the violations.
Any objection?
No.
All right, did you understand by pleading true to violations 4 and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand that? And up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, ma'am.
Court will find violations 4 and 1 true. Is there a proposed agreement?
No, Your Honor, we were going to go open to the court. The state was going to recommend 6 years TDC.
All right, so the state is asking for 6 years, defense?
Judge, I don't know if she was just sworn. Can I have my client testify briefly?
Yes. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Megan Hayes Wilhite.
All right.
Megan.
Just one moment. There's Rutland. All right, who are these people? Are they on the docket? The only people who are allowed in the courtroom are defendants. Sorry about that.
It's okay, miss.
Megan, you understand the state is recommending that you go to prison,
Yes, sir.
and you're asking the court to send you to safety.
Yes.
Why?
I want the opportunity. I haven't been able to get any kind of help when it came to drug rehab, and I really do want the opportunity to be able to get clean. I think it's about time that I do something good with my life, and I believe that SafeP would be a reasonable option for me to be able to get clean and do the best I can for myself and my family.
What is your drug of choice?
Marijuana and methamphetamines.
Okay. When did you first start using marijuana?
When I was about 14, 15,
When
and
did you start using meth?
methamphetamines about 32 years old,
How old are you now?
38.
Have you ever received any type of outpatient or inpatient treatment?
No, sir.
In regards to the reporting, you didn't report for those months. Why?
I did not have a vehicle, and I had my belongings taken from me from an individual that I was living with. My phone, everything, all of my email addresses and everything had been changed up. I had no way to contact anybody. And I was just scared to go up to the probation office at that point. I already knew that I'd MTR'd, and I was just scared.
Okay. You understand that you could have gone up to probation at any time and they would have helped you and probably assisted you in getting your identification and that type of stuff, right?
Yes, sir.
Okay, but you didn't do that, right?
No, sir.
So you were placed on probation when, like last year in August?
Yes, sir.
Okay. You didn't receive any type of treatment?
No, sir.
Okay. And so you're asking for it because you don't want to use methamphetamines.
Most definitely not.
Passwords.
State, any questions?
Just a couple, Your Honor. Ms. Wilhite, you did have an opportunity to review the court summary, is that correct?
Yes, sir.
And did you see here that this isn't your first MTR?
Yes, sir.
And isn't it true that at the last MTR, you were told to go to outpatient treatment and that was a part of one of the conditions?
Yes, sir.
And you didn't go?
I don't think that the outpatient was available at that time. They had told me that I was taking classes, but that wasn't, I guess in the, how would I explain this? They had me doing certain things at a certain time, and I'm sorry, the outpatient wasn't at that time that I was going. I was going to classes downtown, but it wasn't treatment at that time.
Pass the witness, Judge.
No further questions.
All right, I have a question. What classes are you saying you were going to downtown?
I was going to the theft classes.
All right, so what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right, why not?
I had been working and I didn't have time to do it at that time. I hadn't been able to make time yet.
All right, so this is what I'm trying to get to. One, was outpatient treatment ordered for you? Yes or no?
Yes, ma'am.
All right. Did you do outpatient treatment? Yes or no?
No, ma'am.
What is your reason for not doing outpatient treatment?
I was, like I said, I was working at the time. I didn't have the time at that period of time. I was going to be making time for it, but I did not have the time at that period of time.
All right. Because, and the reason why I asked that question, because, and if I'm wrong, everybody can let me know I'm wrong. I'm going to take that as a sign of disrespect. But it seems as though you were saying that outpatient treatment wasn't available when the state was questioning you. Did I hear that incorrectly?
No, ma'am. No, not that it wasn't available. It's whenever I was with Ms. Martha Reyna, we were setting everything up. She had me doing the classes at that time, and I hadn't been able to do the outpatient treatment yet. Not that it wasn't available, because it was part of my agreement, but it just, she had me doing the classes. I was checking in and everything like that with her, doing my UAs and everything. I just hadn't done the classes yet for the outpatient treatment.
Okay. All right. Any other questions?
No, Judge.
No, Judge.
All right. Probation.
Yes, Your Honor.
What is probation requesting?
Your Honor, the recommendation on the court summary is if she is not revoked, then to send her to safe P. I would like to point out this is her second MTR. And as she stated, it looks like she may have maybe entered the deaf classes, but they were never completed.
Okay.
So at least we don't have record that they were complete.
All right. Anything else from either side?
Just brief argument.
All right, then I'll hear argument. State you are requesting 6 years.
Yes, Judge.
Is there anything you wish to add?
Judge, it's just, she's been given plenty of opportunities to attend treatment. Even when answering the questions on treatment today, she didn't really give an answer other than she didn't have the time to do it. She's been given chance after chance. That's why the state's recommending time in TDC.
All right, defense.
Judge, the purpose of probation is to rehabilitate individuals. I understand this is Ms. Wilhide's second MTR, but if she's given an opportunity in safety and she's able to no longer use methamphetamines in the future, then that's the win, that's the purpose. And if safety is successful, then she'll be able to complete the rest of her probation. If it's not successful, she'll be back here and you send her to 10 years TDC. So we're just asking for that opportunity to try to get her to treatment so she doesn't continue to use methamphetamines.
All right. Anything else from you, Ms. Wilhite?
No, miss.
All right, Ms. Wilhite. The problem is, it appears that you have started things, but you have finished nothing. And the problem is, you were given a chance at outpatient treatment and you didn't take advantage of it. I could understand if you did outpatient treatment and it wasn't working. And everyone who comes into this court who's on probation, I always say, if there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. Judge, I have a drug problem. Can you help me with that? Judge, I have mental health issues. Can you help me with that? We have an open door policy here. You can always come in and ask for that. But you haven't taken advantage of that. I'm going to grant the motion and revoke you. The state is asking for 6. Defense, what are you requesting?
Judge, we're asking for 4.
Okay. All right, I'll sentence you to 5 years in the prison. Give you credit for any time served. Is there still restitution owed? Because there were several people
Yes,
that
ma'am.
restitution was to be paid to.
Yes, ma'am.
So did they ever put in any amounts of restitution that were due?
Honor. No, ma'am.
All right, so they didn't put in any amounts, so I don't have any amounts, and if they want to do something with that later, they will have to take it up as a civil matter or somewhere else, but this court is not going to put it in the orders because I don't have anything. There's still to be no contact with the complainants that are previously listed. And let me write those down. If you would like, what I can do is I can recommend for you the therapeutic community. I am not in charge of whether or not they give you or place you in the program. You'll have to still request it, even though I put it on the form recommending it. It will not increase the length of time that you are in custody. So for example, if you're coming up for parole in 2 years or whatever, and you have not completed the therapeutic community portion of it, they're not going to say, well, we're going to give her parole, but since she hasn't completed the therapeutic community, we're going to keep her. That's not the way it works. It's just there for you while you're there. Would you like that?
Yes, ma'am.
All right, so I'll order therapeutic community. You're still going to have to ask for it, okay?
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. And state has tendered dismissals in the misdemeanor cases that are pending. All right, is there anything else?
No, ma'am.
That's it.
All right, good luck to you, okay? You're
you.
welcome.
I think this one here is. Yes.
All right, Kevin Owens. Hello.
Judge.
Hi, how are you doing today?
Just to notify the court, I've been talking with Mr. Wilkins, and my client has notified he's never received an offer. So we're at this moment, at least talking to negotiate, see whether they will make him an offer, and then I'll relay that to my client.
All right, so do y'all want time to do that in court now?
Well, he's going to be bringing the file.
I think there's before I had the case, I think there was an offer that's at least written in the file, and probably before Mr. Castellano was on the case too, maybe.
I'm not aware of any.
All right, well, once you bring the file down and y'all do that, just ask to approach and you can skip in line.
Okay, Judge.
All right, thank you. Raul Paral. Yes, good morning. Okay. And probation, this appears to be an application. And Caroline, whenever they're ready on Owens, just let me know. Court is calling 2023 CR 6946, State of Texas versus Raul Paral Jr. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Good morning, Your Honor. Floyd Rivera.
All right, Mr. Rivera, if you could move over to that side. No, your client's in the center. Yeah. All right, counsel, are you Raul Paral?
Yes, ma'am.
How do you pronounce your last name?
Paral.
All right, I can't roll my R's,
A little bit, but it's okay.
but okay. All right. Counsel, have you received all the discovery and did you review that with your client?
Yes, I have. Your Honor.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
All right, I'm gonna need you to make sure you speak up so the
Okay.
court reporter can hear. And Mr. Kelly, if you all can move towards the end.
No problem.
All right, thank you. I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated third or more? That is a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, or right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he is currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Peral, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, I have.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State recommends community supervision. There's to be ignition interlock for half the term, VIP and DWI intervention. Did you understand that to be your plea?
Yes, Your Honor.
Defense, did you understand that to be the plea?
Yes, it is, Your Honor.
State, did you understand that to be the plea?
Yes, Judge.
With regards to your agreement to ignition interlock for half the term, do you understand that whether or not that's removed will be completely up to the court?
Yeah.
So for example, if there are violations on the ignition interlock, everyone knows that it won't necessarily be for half the term. Does everyone understand?
Yes, Your Honor.
Okay. Did you understand that to be the entirety of the agreement?
Yes, ma'am.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 200 hours of community service restitution, and a 2-year Texas driver's license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State overstates Exhibit 1 in all attachments.
The defense has no objection, Your Honor.
You may continue to confer. I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. I've had many meetings with my client at the office, Judge. He's 36 years of age. He's been working for HEB for approximately 8 years. He's got a very stable job. I know that the other 2 offenses were about 4 years apart of each. He understands that now he's in a whole different court, and now he's looking at up to 6 years in prison if you would grant him on this case. The time that I have talked to him at my office, Judge, he's very remorseful. He understands that he has made a bad judgment on your case. I don't anticipate that you will see him here, Judge. He has a good job, and we're asking this court to allow him to continue with his job and to grant the offer that was extended to us, Judge.
All right. Do you have any children?
I do not.
Okay. Do you have a support system in place?
Yes, I do.
Who's your support system?
My spouse, my girlfriend.
All right. Have you done any sober meetings before?
I have.
All right. Are you currently doing any now?
No.
Why not?
Just focus on my job right now and my life getting together.
Okay.
And Judge, if I may add to this, Judge, my understanding based on my meetings with him, ever since the date of the offense, my understanding is Mr. Barral has been clean. He's been very, very scared about this case. And perhaps that may be the reason why he has not, but he's very motivated to do this right, Judge. And I strongly believe if you would give him that chance, you would never see him again back in your courtroom.
All right, this is what the court is going to do. Court will sentence you to 6 years in the prison, suspended and probated for 4 years. There's a $1,500 fine that will be probated. Ignition interlock for half the term. VIP, DWI intervention, DWI education, two-year driver's license suspension. Do a TAP evaluation, follow TAP recommendations. As far as if it recommends inpatient treatment, we're going to begin with outpatient treatment. There is to be 200 hours of community service restitution. In lieu of you're supposed to do 10 days in the Bexar County Jail. I'm going to give you a choice because I know there are issues at the jail right now. You can either serve the 10 days in the Bexar County Jail, in which case they'll take you into custody today, or either you can do that time on GPS. But since you're going to be allowed to work, you will have to be on GPS for at least 30 days. So which would you prefer?
GPS.
All right. In lieu of the 10 days at the Bexar County Jail, it will be partial GPS for 30 days. And he's allowed to work. And we'll do a waiver of deferment of fees. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. And probation will do one field visit and then thereafter as probation deems necessary. And we'll do regular UAs and make sure there's testing for alcohol. And I'm going to order sober meetings. And I know that you're busy with employment, but I'm going to order sober meetings at least once per week. Now, with regards to the sober meetings, if you feel like you need to do more than one, because some people go to sober meetings and they're like, this is great. This is really helping me. If you feel like you need to go every day, that's not going to stop you from completing your probation. I'm not going to say, oh, he needs sober meetings every day. We're going to extend him. You understand?
Yes.
All right, probation. Is there anything else he needs?
No, Your Honor.
Judge, I have a question on those
Yes.
sober meetings once a week. For what duration of time are you going to have them do those?
Just until further notice. And if he feels that he needs to stop or he's done enough, don't approach the court until 90 days have passed. You understand?
Yes.
And then I'll consider it. All right. Is there anything else you need from the court?
No, ma'am. It's gonna be.
All right. I'm going to show you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes.
All right, so we're going to go off the record. Here's the thing. DWIs are very dangerous. Nobody ever goes out drinking and say, oh, I'm going to go out and get something to drink and pick up a DWI, or I'm going to go out and pick up a DWI and maybe kill someone. People never have that intent. Maybe they're going out to dinner. They're just going to have a glass of wine. Then the next thing you know, it snowballs. Since you're on probation, you're not allowed to drink alcohol at all. And that's just not because it's an alcohol offense. Everybody who's on probation, you're not allowed to drink alcohol at all. You're not allowed to do marijuana. That's the law. You understand?
Yes.
If something comes up and you feel like there's an issue you have and it's not being addressed with probation, you can always come back to this court and we can have a discussion about it. Okay? All right. Good luck to you.
All right, we appreciate your time, Judge.
Thank you. Yes.
Judge Roberts.
Yes.
Megan Wilhite, she spent about 6 months in San Jacinto County, I
Mhm.
believe, when there was a hold from Bear. If I get proof of that, can we?
Yes.
Okay,
Yeah. Just bring it in to the,
I'll try to bring it in tomorrow.
okay. And what's the name of the county?
San Jacinto County,
Let me see if I spell that right. Is it Jan?
JACINTO.
CINTO.
Cold Spring, Texas, Judge.
Okay. And that still doesn't tell me where it's located. I'm still dealing with parishes. I'm getting there.
Okay, I'll bring it in. Thanks, Judge.
Sure. Who's here on John Schulte? All right, we'll come back to you as soon as he comes in.
Yeah.
Christopher Morrison?
Morning, Your Honor.
Good morning. Good morning. So this is a case where you all are asking that he be allowed to reside in Indiana?
Yes, Your Honor.
Have you all conferred over this?
We have.
Is there an agreement or no?
There's an agreement, Judge. It appears that that's where he's primarily living. He's been showing up for every court date.
All right. So is there any concern that the complainant is in Indiana at all?
No, Judge.
There's not.
That's
Okay.
based in San Antonio.
All right. So we're going to go to record in 2023 CR 4707, State of Texas versus Christopher Morrison. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Shannon Locke for Christopher Morrison.
And are you Christopher Morrison?
I am.
All right. The court is in receipt of defendant's motion to modify conditions of bond to allow the defendant to reside outside of Texas and outside of Bexar County. Any objections from the state?
No, Your Honor.
All right. And any concerns that the complainant is in Indiana?
No, Your Honor. My understanding from reading the notes in the case is that when he spoke to our victim advocate, he's based in San Antonio. He's changed apartment, so he's here in San Antonio.
All right. So the court will grant the motion. All previous conditions that are on file, those still remain. So if there's a no contact order in place, that no contact order still remains. You understand? And is there any drug testing or anything of that nature?
I check in once a week with the Mrs.
His pretrial officer.
Oh, okay. Well, here's the thing. We were here for today is supposed to be plea deadline date in VTC. If he's not going to be living here, he's not going to be eligible for VTC. So unless they have VTC in Indiana, if you want to check on that.
And they do not, Your Honor.
Okay.
And so that we have checked on that. There's no way for us to work out a VTC solution to this case. So we're looking at other options.
All right. So is this going to be a jury trial? Because today is the plea deadline
So
date.
they've made a plea bargain to us. They've made an offer. They extended that today. We're still in active negotiations over that plea bargain. And so we would ask for another plea bargain date if we could get one.
All right, Ms. Ferguson. On this case, give me a 30-day reset for plea bargain. The plea bargain date will not be extended past this date.
Understood, Judge.
All right. And it's on Christopher Morrison.
We can do November 30th.
All right, so November 30th, on that date, you need to let the court know whether or not you're accepting the offer. You understand?
Yes, sir.
All right, is there anything else?
Nothing further, Your Honor.
All right, you all are excused.
Thank you, Judge.
You're welcome. Well, after you sign the reset form. Gabriel Bernal and Norma, can you call Mr. Young and let him know his client has shown up?
Yes.
Good morning, Judge.
Good morning. How are you doing?
Good. Good. How are you?
I cannot complain. Let me see. I don't know if that would, it should appear on the docket, Norma.
All right. I got it. Thank you.
All right, thank you. All right, on this case today is plea deadline date, and then there's supposed to be a motion to suppress or something. Where are we?
That's correct, Judge. I spoke to the defendant. The defendant
has asked me to request more time on his case. In the alternative, I think he wants to make a request that he needs want to hire somebody else or have me dismissed of the case, Judge.
All right, well, the dismissal of your attorney, that's not going to happen. So if you want to hire an attorney, you're more than welcome to do so. Do you understand?
Yes, ma'am.
All right. I don't know what's going on with your relationship with your attorney, but what I,
Good. It's just, I don't know why he put it like that.
I'm sorry, what?
No, he's good. I don't know why he put it like that.
Oh, okay. All right. So he is fine with you.
Oh, okay.
I
Okay.
need more time.
All right. More time, what, to make a decision?
That and because when I got transferred from juvenile, that I had a case, and they told me they were gonna try to get, from the prosecutor was gonna talk to this prosecutor. So I was just waiting for that.
Oh, have you talked to the prosecutor in juvenile?
I haven't. I was at the juvenile courthouse yesterday, Judge, on an unrelated matter, but nobody was like, hey, Hank, we want to talk to you about this case. So I mean, I just don't know who to.
All right.
reach
Who's
out
the
to.
prosecutor? Do you
I don't
know?
even know her name.
Oh, so it's a,
Judge named
oh, what's the judge?
Judge Valdez.
All right. So it's a female prosecutor then
Yeah, it's a
in
female
juvenile.
prosecutor.
So,
I got transferred. I had to do like, it's because I've been on probation since a long time.
oh, so you were already on probation as a juvenile?
Right now.
As a juvenile.
I know I got transferred to the county.
Okay. All right, then. So how long do you think it'll take you to get in touch with the juvenile prosecutor? And we won't be doing it today.
I mean, if you could ask the defendant and counsel to stick around, I can make a phone call and see what's going on. This would be if I call over there and they're like, yeah, that's what's going on, then we can, maybe resolve this today.
Okay.
And if it's not, we can get a new date. I do have the witnesses here for the motion to suppress, and I would like to release them if I can.
All right.
It's up to the court, Judge.
No, I mean, it's up to defense. Do you still want to have a motion to suppress or no? He says he has witnesses here.
Can I talk to my client?
Sure. And go ahead and see if you can call the juvenile prosecutor. They may be busy because it's morning for them as well. And then you need to talk to your client about this motion to suppress, because either you're going to be waiving the motion and it's not coming back as far as pretrial is, maybe during the trial, but not as pretrial. You understand?
I understand, Judge.
All right.
That's why I want to make sure he understands it.
Okay. All right. Thank you.
Thank you, Judge.
Kavonda Jackson and Deputy Laura. My mom had a long conversation with me, so we will be recessing exactly at noon.
I already texted everyone.
Thank you. All right. Court is calling 2021 CR 5896A, State of Texas versus Kavonda Jackson. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Ray Lopez for the defense.
All right. Are you Miss Jackson?
Yes, ma'am.
All right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I did.
Okay. Are you the same Kavonda Jackson who was placed on deferred adjudication in 2021 CR 5896A for the offense of possession less than 1 gram on November 18, 2021 for a period of 2 years? Is that you?
Yes, ma'am.
All right. State.
Violated condition number 5 in Bexar County, Texas. The defendant, Kavonda Tanae Jackson, did then and there fail to report to the supervision officer as directed for the months of August and September 2022 in violation of condition number 5.
How do you plead to that? True or not true?
That is true.
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
All right, court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Judge, SATIV followed by aftercare. And a 1-year extension to her probation term.
Is that what you're requesting?
That is, Your Honor.
All right, Ms. Jackson, do you understand what both parties are requesting?
Yes.
So they want you to go into inpatient treatment. Here are your choices. You can go into inpatient treatment or either I can revoke you. Sometimes I can't give people choices, but I will give you a choice. Here's your choice. You can go to SATA, hopefully get your drug issues resolved where you can be clean and sober. I see where I said CPS compliant, so obviously there's children involved. So you can either do that or either I will revoke you and sentence you to 18 months. Which would you prefer? All right, the court will deny the motion. And Ms. Abrams, we'll refer her to status, but however, if there's some mental health issues, then she'll probably need to go to safety. So I'm going to deny the motion, alternate amend conditions to include SATF, and if not accepted as.
A courtroom can change a person's future in just a few minutes. But sometimes the biggest moment isn't when a sentence is announced. It's when a judge realizes there's a deeper problem that punishment alone won't fix. In today's case, what starts as a routine drug case quickly turns into one of the most thoughtful courtroom exchanges you'll see. Stay until the end, because the judge makes a decision that surprises everyone in the courtroom. The defendant appears before the court after entering a plea, hoping to receive deferred adjudication. As the hearing begins, the judge carefully reviews the case, asking simple but important questions about his life, his family, his employment, his future. The answers immediately raise serious concerns. The young defendant admits he isn't working and is relying on his girlfriend to support both him and their 5-month-old baby. He also reveals that he has schizophrenia and is currently waiting for disability benefits. That's when the judge pauses the hearing and shifts the entire conversation. Instead of rushing straight to sentencing, the judge focuses on something much bigger: public safety and the defendant's mental health. She explains that probation alone may not provide the level of support he truly needs. A person struggling with serious mental illness, she says, needs consistent treatment, medication management, and close supervision, not just another set of court conditions. The judge asks whether anyone has considered referring him to mental health court, a specialized program designed to help people receive treatment while remaining accountable. She explains that participants receive regular monitoring, case management, and support to help them stay on medication and avoid returning to the criminal justice system.